Thank you, Jessica, and good morning, everybody. It's a pleasure to be here. I just want to make a couple of preliminary comments. The first is, I know Judge Grant's wife, and I know the Chief Justice's wife. They're very lucky. I'm lucky also. That's just my preliminary. The second thing, I know where my bread's buttered. The second thing is that I've heard half a dozen people mention Andujar and 2 mention Dangcil. I'm just saying. So this part is really about Dangcil. So let me tell you a little bit about that before we begin. Wildemar Dangcil was awaiting trial for multiple offenses, including attempted aggravated arson, when the COVID-19 pandemic hit. Defendant's trial was adjourned for 5 months, and in the interim, this court implemented a primarily virtual hybrid jury selection process while attempting to preserve most pre-pandemic practices and procedures. Ultimately, defendant's trial took place in Bergen County after unsuccessfully challenging the array as not being drawn from a representative cross-section of the community. The jury convicted defendant, and the judge imposed an 18-year term of imprisonment. We granted direct certification to Dangcil's challenge of our new hybrid selection process and pre-voir dire jury excusals and deferrals that remained largely unchanged during the COVID-19 crisis. We affirmed defendant's conviction, finding that the pre-voir dire disqualification, excusal, or deferral of jurors is not a critical stage of the prosecution in which the substantial rights of the accused may be affected, entitling defendant to be present or be represented, and that defendant failed to support his representative cross-section claim. Defendant did not establish that any cognizable group, however identified or classified, was excluded from the jury in this case, or that there was a substantial underrepresentation of any cognizable group. We also concluded that the jury selection procedure employed was facially neutral, and defendant did not show that the neutral procedure was applied in a discriminatory manner. However, and the reason we're here, we did acknowledge that the Dangcil case did raise some important issues, though not substantiated in that matter, that convinced us to seek more information about jurors' demographic information in an effort to assure that a fair cross-section is represented by the summoned jurors. Juror disclosure will be voluntary, or would be voluntary, and cover a juror's identified racial identity, ethnicity, and gender categories. Now I'm going to turn things over to Judge Grant, our acting director of the Administrative Office of the Courts, to review what we will attempt to do to comply with Dangcil's instructions. And he'll also discuss, I believe, the timeframes for implementation. Then Acting Attorney General Andrew Bruck will have a chance to speak, and Alexander Shalom, Supervising Attorney of the ACLU. They will present what some other jurisdictions are currently doing in this area. Judge Grant?
Thank you, Justice Solomon. Go to the slide. Justice Solomon is taking care of the first few slides.
Sorry.
Oh, no problem. Next. And right there. When we start talking about Dangcil, and this was an opinion written by Chief Justice Solomon that was unanimously approved by the members of the court. And the court, from my perspective, is really now trying to design the electrical wiring of this new house. If you don't have wiring, you can't see what's occurring, what needs to be renovated. And since we were not capturing that data, racial data, the court said that the judiciary should begin to collect the data in order to understand the diversity and representatives of jury pools. But the important part here was that it would be voluntary, that responses to these questions are optional and will not affect your selection. Next slide, please. One of the questions that was raised yesterday was, how do you compare representatives? And the court decided correctly, in my opinion, that the questionnaire will be modeled to include the race categories used by the US Census, asking people to select responses that most closely align with their racial identity. And those identities are American Indian, Alaska Native, Asian, Black or African American, Native Hawaiian or other Pacific Islander, white, or more than one race. Next slide, please. Again, relying upon the US Census, the categories would also try to identify the ethnicity of an individual, whether Hispanic or Latino, not Hispanic or Latino. Next slide, please. And then selecting a gender category, not based upon the US Census tract, but based upon New Jersey statute. As you know, New Jersey statute allows for non-binary or undesignated designation, as well as female or male designation. Next slide, please. I am now going to turn the presentation over to Mr. Salone to talk about other models of collecting data.
Thanks, Judge Grant. So New Jersey, in the Dangcil opinion, wasn't totally writing on a blank slate here because there are some states that collect demographic data, though there are some flaws in it. So New York, for example, does collect demographic data, but as you can see, they only do it for reporting jurors. So if you go back to Professor Chernoff from yesterday, who had the kind of flow chart of the hidden parts of jury selection and then the visible part, the invisible and the visible, all of the invisible stuff is not captured. We don't see who's responding. You only get people when they get to court. And then if you go to the next slide, please, you'll see what information is provided annually by county. You see who's showing up. But there's a lot of information, of course, not included there. We don't know how many people were summoned. We don't know what people get excused for hardship, for cause, on a peremptory basis. Connecticut, on the other hand, which is going to be the next slide, does a more robust and searching inquiry. And this is recent legislation in Connecticut. They collect this information at the qualification stage rather than at the reporting stage, so earlier on. And it's more robust. If you go to the next slide, you'll see exactly what they collect in Connecticut. It's not everything, as you'll see, but there's who's summoned for jury service, who participated in a panel, who gets excused on a peremptory basis, who gets excused for cause, and who actually serves on a jury. So there are still a bunch of things that are missing, but there's some really good elements to this Connecticut statute. And the other thing that you'll see at the end here is that although there's no personally identifiable information, this information is made public. So it's published on a website. So you can see in a particular county, for example, what is the change from the general demographics of the community to the demographics of the people who are showing up, to the demographics of the people who wind up ultimately serving on a jury.
Thank you. Sure. Next slide, please. So New Jersey's strategy at this juncture, and we're looking to hear from all of you with regards to your thoughts or ideas, is to begin to collect voluntary jury demographic information at the point of qualification rather than reporting. This will enable a more comprehensive baseline that includes jurors who do not ultimately report for service. It can also, as you've heard many of the speakers talk about, allow us to begin to assess what happens at the various processes that affects demographic compositions at each stage of the selection process. Next slide, please. One of the things that we're using this forum from is to try to engage in the timing of this collection of this data. It takes 8 weeks to notify a juror for a jury service. Our goal is much more expansive than what's currently going on in New York. We would look to at least capture this information on a more consistent and regular basis. We would look to revise our questionnaire and to substitute the existing questionnaire with the responses both online and in the hard copy to collect this data and to begin sharing it with the attorneys, sharing it with judges and others. But this conversation is really where we want to hear from all of you. Last slide, please. Time frame for implementation. We have to test the processes. We've got to plan this. We've got to do a major renovations to our current system. Again, the demographic information will be voluntary. It will be requested from summons jurors during the qualification rather than the reporting phases. jurors will not be excluded. As the court wanted to specifically note, they will not be excluded from these jury service because they did not answer the questions. And we would then create a framework for sharing this data with all of you and others.
Okay, we'll entertain any questions, but I had one question or thought, Judge Grant, I guess this applies to you, is what are we going to use as the baseline? Are we looking at statewide census data, more localized community area data?
We're going to look at the county data. That's how we ask, that's how we summon jurors, so we're going to use them on a county basis.
So the demographics of the particular county will
Correct.
be reflected in the data?
Correct.
Okay. And obviously, this is useful to the attorneys who started us thinking about this. Are they going to be able to inquire about individual juror census data, census type data?
We will give them raw, just like we did with the Rule 185, we will give them the information about the person's racial demographic ethnicity or racial ethnicity at that time, but we will not give them the individual names of those judges, of those individuals, I'm sorry.
Okay, General Bruck and Mr. Shalom, this probably applies to you. Should the aggregate data that's sent to the attorneys include information in addition to that provided by the rule, such as the municipality, zip code of the individual juror, and other things you can think of? What kind of information should be available and disclosed upon request or generally disclosed?
Yes, so I mean, I think the general view is more data is better as long as it is not identifying individuals. As long as we can anonymize the data, it is helpful for the lawyers to have the information, it's helpful for the courts to have the information, and it's helpful for the public to have the information. We created earlier this year within the Department of Law and Public Safety and Office of Justice data because we were collecting so much data ourselves. And I think one of the principles that we've adopted is when we collect that information, we want to make sure that we're making it as easy as possible to collect. We're actually analyzing that data, make sure it's not sitting on a shelf, and then we are actually publishing that data. And our general view is we release to the public as much information as we can in the fullest data set possible without revealing individual identities. And we have found in particular that researchers don't want us to release a PDF of data. They want the underlying information so that they can analyze it themselves. They'll make insights in that data that we wouldn't get ourselves.
Is there data in addition to the rule that specifically you think is informative?
I think you were right, Justice Solomon, to mention zip code. We heard from Professors Chernoff and Rose yesterday about a model of replacing jurors who fail to respond to summonses with jurors from the same zip code. And I think it was Professor Chernoff said it, and I'm not sure how residentially segregated New Jersey is to see whether this is, but pointed to the fact that New Brunswick is. But we know that that's not New Brunswick, that's New Jersey. New Jersey is so deeply residentially segregated that there's a lot of value in learning about zip code because it really does correlate so deeply to other cognizable areas.
You should know that the court has already approved that process. So we will be sending out that second notice to the zip code area. So the court's already done
I
that.
just wanted to hear whether they thought we were going in the right direction or not, even though they don't know what we've already done. So just check, in the interest of fairness. So presumably, although I guess we don't really know, we'll see what the numbers say, there's going to be some disparity between expectation based on census and what actually comes in terms of data. Your thoughts about what we're looking for, what to be concerned about? Is there a degree of disparity that is significant to you all as coming from different sides of the bar?
Sure, thanks. I appreciate it. And one thing I've always appreciated about the New Jersey judiciary is I often get invited to these things despite the fact that I threaten to sue them. And this is no different, but because it might come before the court. All judges and prosecutors, just close your ears. I'm really talking to people who aren't judges and prosecutors here. But no, what I want to do is tell you a little bit about State v. Ramsar, which was, as you know, the first capital case that the New Jersey Supreme Court decided. And it's a mammoth opinion. It's more than 100 pages. But in Ramsar, there was a challenge to the composition of the petit and grand juries in Essex County. And ultimately, the court rejected that challenge. They said that the defendants had failed to bring forth sufficient evidence to show that there was not a fair cross-section of the community. But there's some language in Ramsar that I think people who like to sue people like me can use going forward. And I think it's very informative in this process because, as we know, some of the things that we've talked about, like juror pay and the absolute bar on people with criminal convictions, will require legislative change. But perhaps this is a message that this is legislative change that is constitutionally moored, and a failure to act can cause constitutional problems. So I just want to read you a couple really quick clips from the Ramsar opinion. The court rejected the idea that had been found by other courts that if you just pull from voter lists, which are themselves neutral, that the process is insulated from constitutional challenge, and said the fair cross-section principle, however, is designed to achieve results, not just assure opportunities. Thus, compilers of juror lists may drift into discrimination by not taking affirmative action to prevent it. And then said, even though we're within acceptable limits here, if we accept discrimination for a long period of time, knowing that it exists, it can cause a problem. And so I say that to say, we're going to get some data, and it might show that in a particular county, there's a disparity between the census data and who's actually serving on juries. And that may or may not be a constitutional issue right away. It might be, depending on how severe the disparity is. But a failure to act to remedy it, to take affirmative steps to shrink that gap, can over time create a constitutional challenge. So the judges can now tune back in. Everyone can listen again.
I'm reluctant to say how much I enjoy Alex personally, given how often he sues me, and now it's my name appearing in the caption. I think those are reasonable points. I want to talk about one issue in particular that's especially important to us when it comes to demographic data, and that's the demographic data surrounding grand juries. And this is particularly relevant to the AG's office because I think, as most of you know, in 2018, Governor Murphy signed a law requiring that the New Jersey AG's office, as opposed to the county prosecutors, are now responsible for investigating every fatal police encounter in the state. So all officer-involved shootings and any officer-involved shootings that result in death and any deaths in custody. And one of the things about that law that is really noteworthy, and I don't think exists anywhere else in the country, is a provision that says that our office is required to present every single fatal police encounter to a grand jury. So unlike the normal course where prosecutors only present cases to grand juries when they're seeking an indictment or when they believe that an indictment is appropriate, we are legally required to present every case to a grand jury. And when that law passed, we recognized that we had a special obligation in our office to make sure that, because of the way the legislature structured this, that we would present cases fairly and neutrally to the grand jury. We would not go in there and try to put our fingers on the scale for whether there should be an indictment against an officer who was involved in a fatal police encounter. Earlier this summer, we issued guidance to our prosecutors as to how they should do these presentations to make them as fair and neutral as possible, give the grand jury the facts of what happened, elicit the testimony, but leave them to decide whether the officer should be indicted. We think that's the right and fair thing to do, and it's designed to avoid, I think, the problem that my colleague in Kentucky encountered with the way that they handled the Breonna Taylor grand jury presentation. But when you have a structure like that, where the prosecutor is not advocating for an indictment in the grand jury, it then shifts the focus to what is the grand jury deciding, because it is 16 to 23 citizens who are deciding whether or not these officers should be indicted. And as you take the focus away from the prosecutor, the focus shifts to that grand jury. And we have started to receive questions from the public. Okay, so who are these 16 to 23 people? And obviously we're not going to reveal their identities, but I think people have a reasonable interest in knowing, does that grand jury reflect the diversity of our state? And I think that having more and richer data will help answer that question. so that either we can identify a problem if it exists, if it doesn't reflect that diversity, or if it does, then we can share that with the public to help bolster outcomes in the process, if not with the substance of the cases.
I think that challenge is the same challenge we face for pettit jurors as well. When you talk about cross-representativeness, when you talk about the community being represented in our juries, it really applies whether it's a grand jury or a pettit juror. You just have more public spotlight on the challenging case than with a police-involved shooting. But this larger question of who is participating in our jury trials is really the focus of this conversation. Are you really getting, this large cross-section of the community, or is it still just people who have the economic circumstances to participate in the jury, or those who can't participate in the process?
Just one more word on Ramsar. I'm not totally obsessed with it, but just to talk about how far we've come and how important the requirement from Dangcil really is. There will be data people who will be able to crunch these numbers coming in spreadsheets. They talked a little bit about the methodology during Ramsar and the way the Office of the Public Defender had to go about trying to prove disproportionality was to send some people with clipboards to stand in front of jury control in Essex County to try and figure out who was walking in the door. That's crazy to imagine that that was the methodology. And so we've really come a long way, or we will come a long way when we have real numbers to look at, to have honest conversations about, the grand jury is often called the conscience of the community, but it can't be the conscience of the community if it doesn't represent the community. And the pettit jury, it's the same idea, right? We talk about fair cross-sectionality, which is this constitutional jargon, but really what it means is when someone's liberty is at stake, who's getting to decide that? And it's just so critical that we know whether we have a fair process or not and fix it if we don't.
Picking up on what you said or asked, because it's all going to depend on who answers and who doesn't answer. And it's going to be voluntary, presumably, unless we're dissuaded from you making it voluntary. Is there a concern that asking for this kind of demographic information will discourage prospective jurors from responding to summonses, appearing for juries, willingness to serve on juries? Is there a concern about that?
Short answer is, I think it has to be. We have a very consistent with the national average. About 30% of the people are, actually responding to those summonses. In some counties, those numbers are less than that. I'm thinking about Essex. So now if you add another factor where people will say, I'm not even going to respond to that, I'm not going to go and deal with that issue, you could potentially reduce the pool, the number of people that are willing to participate. It is a risk, I think, that was worth taking, that the overarching benefit of identifying, again, putting the lights on with regards to this important question is so important that we can't be concerned about that issue. We may have to look at it down the road, but clearly trying to capture that information is really, really important.
I mean, it's an empirical question, right? We can compare after however long, a year of doing this, are the yield numbers lower? I have to say, my guess is they won't be dramatically. I mean, the voir dire process is a pretty invasive process. We ask a lot of questions, and the kind of banal census questions that we're talking about here, I think are the sorts of things that people are used to responding to in lots of contexts. When you fill out any survey of any sort, you tend to be asked those questions. So my hunch, though it's not empirically tested, is that there won't be a significant reduction. But like Judge Grant, I think it's a risk worth taking because it's so important that we measure this.
I mean, one thing that we've found, because we do a lot of data collection, is just make it as simple as possible. If you put in any friction, you're going to lose people. So make it as simple as possible. And then you have to balance a desire to have as much data as possible because we want to have these rich data sets with making it so that it takes as few seconds as possible for someone to complete this and return it.
Alice was talking about the old system. What was that? What was the case, the year of that?
It was a 1987 case, but an 85 trial. So they were assembling that in 85.
So we have this extraordinary investment in technology. Technology allows us to host this event. And fortunately for the judiciary, we've got a statewide information technology system that's second to none. We've been able to capture that information at the county level, identifying who serves on our jurors and going forward. we have a significant percentage of our jurors who are now filling out those questionnaires electronically. I would say probably 7 out of 10, 8 out of 10 are filling out electronically. And before COVID, we were looking to advance it even more with the campaign. We may have to get back to that, but we've been very successful with this really extraordinary technological foundation that we were able to create.
And I just want to echo that. Maybe it's inappropriate for me to say. Somebody who is low tech, I use pencil and paper. I'm not I'm pretty good on a keyboard, but I'm not great with it. Our IT staff, Jessica's over there kind of running the show for me, and she's gonna make sure I don't do anything wrong. But they are absolutely incredible. The amount of information and the way that they assimilate information is also incredible. And just as one example, we had oral argument scheduled for the day when the big storm hit and Jersey was shut down. And they literally converted from in-person argument to virtual argument in seconds. It was the most incredible thing. So I'm just putting in a plug for IT because they really take care of somebody as ignorant as I am.
I want to go back to criminal justice reform, and it involves Joe Kokora and Mr. Salone. When we did criminal justice reform, before we were able to get our data, the ACLU was saying, please give us this data to capture this information. We were looking to get it. And similarly with this initiative, the judiciary has received, Public Defender Kokora, multiple requests for this demographic data, even though we haven't started collecting it from the public defender's office. So,
Yes, I always respond no, don't I? So if the data does show that that what we're getting doesn't compare to the census data, it's not, I'm not saying exactly equal, but there's a substantial disparity. Is there a thought about targeting specific groups of prospective jurors, making the requests or the summonses or the lists we're working from more directed so as to try to approximate what that census or general baseline data is?
So I think there are a couple questions. The first is, and because the proposal is to collect this data early in the process, we're able to see in which of the bands that Professor Chernoff talked about the problem is happening, right? Is it that fewer people are coming to court, or that they're all getting excused for hardship, or that they're getting excused for cause, or that it's peremptory challenge? We'll be able to look at that. And I think the response will have to correlate to what the problem is. So if we see, for example, that it's hardships, that you have a semi-representative jury that becomes unrepresentative after hardships, that would be a strong pitch for increasing juror pay, for example, or providing daycare and the various things that we heard about yesterday from Mr. Snowden. So we have to tailor our response to the problem, but we also have to say that if we identify the single largest source of the problem, that doesn't mean that we don't fix the things that aren't the single largest source of the problem. And so we need to be holistic here. And if there are the 7 steps of the jury selection process, there's no reason that we should be tolerating any step that makes our juries less representative. To your question of targeting, I think the answer is yes and no. I mean, I think there are some methods that have been time tested, like replacing people who fail to respond to summonses with other people from the same zip code. That seems like a sort of targeting that is generally unobjectionable, because you're talking about what is basically a semi-random process to begin with. I think noting that peremptory challenges, for example, if that were to be revealed as a source of disparity, to say, well, the solution there is to rig the peremptory challenges differently, which is to say, give someone more, give someone less. That seems more problematic, because that seems like you're solving discrimination with more discrimination, whereas the other one seems like a target to try and prevent the kind of legitimate fallout that we know happens because of economic realities and other things.
I think one of the challenging questions that you're going to have is really for the court is, where do you draw that line, right? So we're going to get involved with the collection of the data. We're going to do that assessment. It may be that it's due to exclusions or disqualifications related to felony convictions, but where does the court draw that line? So I would say that it will be an issue. I'm certain there's going to be quite a few cases that are going to be coming to the court over the ensuing years as to where they think it's appropriate to say this is a constitutional deprivation or it's not a constitutional deprivation. So,
But if we can just pull from criminal justice reform one more time, because one thing that made me so proud to be part of that process was there was this kind of collaborative process where the attorney general and the public defender and the county prosecutors sat down and we came to this agreement on a lot of stuff, but not everything. And even at the time that we were sitting there and holding hands and singing Kumbaya and talking about how great it was, we knew there would be questions that would be resolved by the court. And that's okay, because in an adversarial system, you don't have to agree on everything, but if you can agree on most things and move the system forward, that's useful. And I think the same is true here. Getting this data, getting a better system, and then we're going to still have to have lawsuits about it. That's the nature of an adversarial system, and that's okay. It's healthy.
So you're not going to stop suing me?
Definitely.
so Ms. Lewis Kelly has said it's 70% of summons jurors respond to the summons. So I make that correction. Thank you, Ms. Lewis Kelly.
And just, for
But
clarity.
that doesn't apply in all counties.
I would suggest that we take Mr. Shalom's suggestion as to how much disparity we should tolerate and General Bruck's suggestion and split it right down. No, maybe not. Maybe not. Just my thought. Are there any questions? We're almost out of time. We got a few more minutes. So I'm thinking maybe there's some questions out in the audience. And if you have any, step right up. Otherwise, I'll fill space with jokes and we'll tap dance something. No questions at all? There are, obviously, we're going to try to figure out how to get the most representative sample based upon the most appropriate questions and forms. Do you have any suggestions about what kinds of things, other than what we've discussed here, what kinds of things we should be trying to do, looking for, questions we should ask, things we should avoid? I think you've touched on some of them. I'm sure there are other ideas you have.
One thing from a data collection standpoint that stood out during Dr. Rose's presentation yesterday was the, under the kind of pre-existing system, the clumsiness of what was excusals for cause, because it really aggregated together excusals for cause, hardship challenges, and even in excusals for cause, you've got the kind of consent excusal for cause, right? The juror we saw from Kentucky, I don't think there's a prosecutor in New Jersey that would say, no, that person should serve on the jury. Everyone's gonna say, yeah, get that person out of here. The hardship excusals that are either economic or travel-based, those are all consent, versus what we saw in Andujar, where you had a prosecutor fighting for a cause challenge and the defense attorney arguing against it. Those, it seems worthwhile to separate those out, because I think that will give us a fuller sense of what's happening to shape the shape of the jury.
And that analysis about how far you go down that rabbit hole, if you will, that granular detail, if you will, because that data is not collected in the jury system, or maybe collected in the jury system, but it's the jury staff in the courtroom that's collecting that data, as opposed to the jury manager who's collecting the initial information when one is responding to the summons to appear before jury duty. And so there is some analysis that the judiciary would have to make as to what is the ease of getting down to that actual level. We know we'll be able to, if you're looking at that funnel that Professor Chernoff talked about, we can get it at the beginning parts. Now you're on the other side of the funnel where you're actually in the trial work, and we'll have to engage in some conversations with our staff, with the TCAs and others here as to how easy it is to get to that specificity. So,
And I don't have like specific substantive suggestions about what kind of data we should collect, but I do think that as sort of from a process perspective, it's important to talk to the researchers and statisticians who do this for a living, because I am sure there is stuff that they would really like to know that wouldn't even occur to us, that if we could add one additional question would totally change the way they analyze their information and could give us much more helpful insights. And so I think sitting down with them and seeing what have you not been able to suss out of the data will probably make their lives easier and ultimately our lives better.
I think we're about up. Okay. Thank you all. Thanks to our panelists. Very easy to ask you a question, let you run with it, and like what you have to say. I'll try to say yes to a couple here. Thank you.